New York Judge Juan Merchan has just delayed a major ruling on the future of President-elect Donald Trump's hush money conviction. The judge was scheduled to decide today whether Trump's 34 felony conviction should be tossed out in the wake of the Supreme Court's presidential immunity decision. But now that deadline has been pushed 1 week to November 19th. Joining me now, MSNBC legal correspondent Lisa Rubin and former Manhattan prosecutor Duncan Levin. It's great to have both of you here on set. Why, Lisa, did the judge delay, and what does this mean?
Chris, there was a joint application essentially from both sides. The Donald Trump side saying it would be unconstitutional to force him to go through a sentencing as a future president because the same constitutional concerns that would animate, for example, prosecuting a sitting president, those apply when you're sentencing somebody who's about to be president, according to them. They say his time right now needs to be absorbed by planning for his presidency. And you have the DA's office saying, look, there are conflicting values here for us. On one hand, we want to uphold the jury's verdict. We believe in that verdict. And we believe that it was reached with a presumption of regularity. On the other hand, the office of the president presents special constitutional concerns. We want to think about it. We'd like to get back to you in a week.
Okay, I want to play what DA Alvin Bragg said after Trump's guilty verdict.
While this defendant may be unlike any other in American history, we arrived at this trial and ultimately today at this verdict in the same manner as every other case that comes through the courtroom doors, by following the facts and the law and doing so without fear or favor.
There was so much involved in this. Obviously, Duncan, you know this, thousands and thousands of hours. The amount of stress that comes from prosecuting a case against someone like Donald Trump. And when I say someone like Donald Trump, there is no one like Donald Trump in terms of a defendant and his fame and his notoriety. What do you imagine the conversations are like behind the scenes right now?
Right, to be a fly on the wall there, but there's no playbook for it. And so they're trying to figure it out themselves, much like the defense lawyers are, much like all of us are trying to figure it out. So I don't think anyone has any magic answers, least of all the judge here who's trying to look to the parties to get some advice about how to handle it. But I think what the DA's office is going to try to do is maintain the conviction in a way that can preserve it against a clear onslaught of appellate review. Look, Trump is going to go to the Second Circuit, which is the federal court now, to try to get the federal courts to review it, because that's his way up to the Supreme Court, which can review this on a number of constitutional grounds. So he's going to try to get this in front of the justices on the Supreme Court as quickly as he can. There's no doubt about that. What the DA's office wants to try to do is preserve the conviction, because a lot of work went into it. He was convicted. And the fact is that the re-election of Donald Trump as president does not really implicate any of the legal issues that underpin this conviction. The conviction stands on its own, and even this immunity issue has very little to do with the fact that he was re-elected as president. So they're going to try to thread that needle to make sure that it withstands appellate review now that he's been re-elected.
So, Lisa, while Trump's cases are in limbo, the Supreme Court today rejected former Trump White House Chief of Staff Mark Meadows' request to move his Georgia election interference case to federal court. What was behind that decision?
Well, I think partly, Chris, we don't know what was behind that decision because literally the decision is a one-line rejection of his petition for certiorari to the Supreme Court. However, what Mark Meadows wanted was to move that case to federal court because he thought he would get a more hospitable hearing to some of the defenses he planned to raise against the Georgia election interference case if it's ever tried on the merits. And in particular, he wanted to defend himself he wanted to say that he was immune from prosecution as basically as close to the president as you could get, that veneer of presidential immunity essentially should rub off on him the way you could rub Aladdin's lamp. As the White House Chief of Staff, he thinks that he should have been immune too because he was involved in some of the same decision making. I don't know that would get any better a hearing at a federal court than a state court, but Mark Meadows believed that it did, and at the very least, it consumed a lot of time, and that may have been the ultimate victory.
Do you see any world in which, Duncan, Mark Meadows can use that the immunity is going to rub off on me argument?
No, I think it's a really difficult argument to make. And I don't think, again, the re-election of Donald Trump is going to change that very much, except to say he's now got a lot more sway over the federal courts. He's got a stronger argument to make that he's sort of in the fold of the presidency again. And so I'm sure the argument is going to get a little bit stronger. But this is something where I think it's a long shot, to say the least.
All right. Duncan, it's great to have you here. It's been a bit. Lisa, I see you in the hallways, but it's good to see you as well.